Hi, everybody. Welcome back. I hope you had a great lunch. It is now 1 p.m. and ready to get this afternoon started. It is my pleasure to announce our instructor for public bid law, Patrick Virgadamo. He is a senior attorney here with the Legislative Auditor's Office. Let's see, Patrick is licensed as a practicing attorney before the Louisiana State Bar and the Eastern, Western, and Middle U.S. District of Louisiana. In his capacity as attorney with the legislative auditor, Patrick has researched and written opinions on numerous and various questions facing the auditor's office, state and local officials, and public entities in general, which arise every day. Patrick is certified as a state agency ethics liaison and certified ethics trainer with the Louisiana Board of Ethics. Patrick serves as an instructor for the LLA's Center for Local Government Excellence. He's also a certified fraud examiner and member of the Association of Certified Fraud Examiners. All right, Patrick, take it away.
Thank you, Lizzie, and welcome everybody. I'm glad to be able to spend an hour with you guys this afternoon. And today we're going to talk about public bid law and specifically some complex recurring issues that we've seen in questions from CPAs and local governments and some potential legal solutions to those questions. So as far as today's class, this is mostly going to focus on the public bid law. We're going to try to talk about some of the underlying principles behind the public bid law so that if you kind of understand those, you'll be better prepared to address and recognize complex public bid issues, as well as apply those principles to get the right answer to your questions and resolve those issues. Some topics we'll go over today that deal with that are disaster and emergency procurement, technology procurement, piggybacking, recurring purchases, trade-ins, and contracts for goods and services, along with national co-ops. So we'll start with what's probably on the mind of a lot of people, especially given the last 2 years with all the hurricanes, the flooding, and things that we've had to deal with, is disaster and emergency procurement. We figure we start with that first because unlike a lot of the other ones that we'll talk about, this is where, because of the exceptions that are in the public bid law for disaster and emergency procurement, you're really not operating under the normal rules. You're doing special rules specifically for that. So in dealing with this, I figure it's easier to kind of come at it from an angle of a scenario. And so what we try to do for each of these topics is give an initial scenario and then discuss in light of that scenario. So in this case, you have a hurricane that passed through, causing significant damage to several local government buildings, including the damages to the roofs. And so your agency head wants to know, are there provisions in the public bid law to take care of these roof repairs without having to go through the advertising and bidding processes of the public bid law? So the answer to that is yes, there are exceptions specifically provided that will allow you to respond to public emergencies and extreme public emergencies without following the normal complex rules of the public bid law. One thing that I think is important is to understand that the public bid law has a very specific definition of emergency. And this is something the AG has kind of called attention to when people have questions that are scenarios that aren't dealing with your normal common examples of like a hurricane, a tornado, flooding, natural disaster type situations. You need to understand that it has to be an unforeseen mischance that brings with it destruction or injury of life or property, or an imminent threat of that destruction or injury. The key thing there is what the AG's guidance has said is it can't be something just because you don't want to have to wait for to go through the bid advertising and bid process. That's not an emergency. It also has to be imminent. We've had some recent questions where people were asking him and he said, if just an academic question where it's a hypothetical, there's no specific facts that say this is likely to occur in the near future, is not enough to arise to the emergency in those situations. So obviously with your natural disasters, almost all of those are going to meet that definition. It's when we try to start applying emergency procedures to things that maybe aren't really an emergency. So the requirements, the public bid law, even though it doesn't require you to follow the normal requirements, in and of itself gives a specific procedures you have to follow when buying stuff under the emergency or extreme of public emergency scenarios. The first and foremost is a declaration of disaster. That's pretty obvious in those situations that involve a natural disaster, but it may not be where it's something that came up that was unforeseen and you need to be able to do that procurement quickly. So once you declare that disaster, the law says you have to publish a notice of that disaster in your official journal within 10 days. If it's an extreme emergency, which like a Katrina situation is the example I always give, the paper may not be running, so it just says, or as soon as practicable. Any contracts you negotiate under this emergency or extreme emergency disaster have to be supported by written determinations and findings that justify why use of the emergency procurement authority was needed and necessary. So that's important, and as any auditors are always going to want, they want to see documentation, not just that you declared a disaster, but why it was necessary to procure stuff without following the normal process to satisfy that disaster. The biggest example we get all the time is, as time passes, it's less likely you should be able to use this exception, because eventually you can just follow the normal processes and still get what you need. If the contract is taken, if basically in that emergency situation, if you're getting telephone or oral offers, you have to have some kind of written confirmation of those offers in your file. So the idea is you want to follow up and have something documentation in your file. The file must contain a minimum of the description of work that's going to be performed, the name and addresses of those people who gave you quotes, and the time and terms of the offer, so that when you're evaluating what you did and why you chose what you did, there's some documentation in your file to support why you chose to make those decisions. If there are quotes that are lower than your accepted quote that are not accepted, you need to have documented reasons in your file why you chose to go with the higher quote. And finally, and this is important for people for records retention scenarios, the law here specifically says those records have to be kept a minimum of 6 years, so that once the disaster is over and people are really evaluating what we did during the disaster, those records are still there. A recent scenario that we've had a lot of questions after the 2 hurricanes and with the increases in lumber prices and things of that sort. The scenario here is you have a contractor who now comes to you and says, after the hurricanes, they can't get the building materials for their public work project that they won at the cost that they put in their bid and that got put into the contract. They want to know, can we do a change order to execute it to increase the cost of the materials under the contract? The answer to that, according to the AG, is no. The AG specifically in opinion 06-0304 said, of adverse weather conditions and disasters are not in of themselves just cause for doing a change order to increase the cost of materials. Essentially, once that contractor bids at a price, they're held to that price standard. The AG also noted if those materials were done under unit pricing, the statute under the public bid law, which is in 38:2212 M5, specifically says where the initial contract had unit pricing, so it was like $10 a foot or however that unit price is set, no change orders can subsequently come along to change that pricing. The unit price has to continue to be in effect for those. Now, technology procurement, we followed disaster with technology because similar to disaster, it has its own exceptions to the normal process that you can use in those scenarios. So in this scenario, we had a political subdivision. They had an existing security camera system, and they're looking to add additional cameras to the system. We get this question a lot. That's why I went with the security cameras. The agency wants to know, are there alternatives to bidding out the process? Because we want to make sure that the political subdivision gets fully compatible cameras and related equipment. Well, the answer to that is yes. The political subdivision's telecommunication and data processing procurement law specifically provides an alternative to the bid law. The key thing, though, is it's not mandated. Unlike for state agencies, which may have scenarios where when they're doing technology procurement, there are specific provisions that apply to that procurement. For political subdivisions, it's just an alternative. What that alternative says is, in lieu of doing the normal advertising and bidding, you can do an RFP process. And so what that essentially allows for is you can use that process to lease, rent, or even purchase telecommunication and data processing systems and equipment. To understand that, the AG in several opinions has given some guidance of what is exactly data processing equipment and telecommunications equipment. Some examples where he has said meets that standard: security cameras, because they're connected to a network, those new smart meters that people see for water meters, because they're made to send data so that that meter reader may not even need to go out in some cases, because they're connected to a system that automatically sends out and reports. Another example the AG has given is the new electronic parking meters, where they kind of send out and notify when there's when someone has overstayed their paid parking, and allows for reading and calculating of the amounts in those. Essentially what you're looking for is it's something that's connected to a bigger system where it either receives or sends out data. Obviously the traditional thing of like a computer and things that are connected like that would meet. But the idea behind this is you get more of a holistic approach to it to decide what is you would want to use. So the RFP process, essentially the procedures that are outlined in the statute. The first and biggest thing is you have to give out a public notice of that RFP at least 30 days prior to the scheduled opening of the proposals. And that's important because that time period is different than the advertising for like materials and supplies under the public bid law or even for public works. So it's a 30-day period. You always need to be mindful of that when you want to do the RFP process. Written notice of that RFP is supposed to be mailed out to people who would essentially, you think would potentially be people that would respond to that RFP. You want to make sure you kind of give them a heads up as well and say, hey, look, we're putting out the RFP. We think you might be someone, this might be one you may be interested in responding to. And so you send it to those people. You can also, and this is permissive, you may also provide public notice through electronic media. Example of that, easiest one of that would be posting it on your website. That's usually a really good thing, because if you really want to try to get proposals, people looking at your website would know to go there, and you can also post other information about the process. The RFP has to, and this is probably the biggest part of the RFP itself, you have to indicate in that in what you provide to the potential proposers, I should say, what exactly, how are you going to evaluate their proposal? What weight are you going to give to things like price, experience, whatever those criteria are going to be? You want to make sure that they're clear and that it lets people know up front what those are going to be. One question we recently got was, can we go in and change that right before the close of the proposals? No. Once you basically provide that process, you should follow that process. Obviously, if something's wrong, you always want to make sure you give yourself the ability to reject everything and just walk away and start over. But it is important, you need to make sure the criteria are clearly laid out, so when they're responding, they know what they're responding to and how they need to respond, as well as timeframes. And if there's changes because of whatever reason, whether we have some bad weather come through, you want to make sure everyone gets an update of if there's changes in those time frames. The award, in this case, it's unlike, say, with public bid where it's just whoever's the lowest. In this case, it's the person who's most advantageous considering price and all the other evaluation factors that you put in your RFP. The idea being, you told people this is how we're going to evaluate you. Your way you award it should follow that criteria. That whatever is in that should also be incorporated. And as we said, you can reject those. You want to make sure you make it clear that you have the ability to reject everything. Because if there's an error, budget issues come up, you want to be able to, as always, tell people, we're just going to reject all and start over. At the end of the day, you want to make sure what that successful proposal that was submitted and met your criteria is used to incorporate in that final contract. It's no different than public bid in the sense that what someone wins as the bidder should be what form it becomes the key parts of that contract that you ultimately make with them to carry out that procurement. One thing that, because sometimes I know people reading stuff all day, it may not make sense to you. We have a lot of visual learners or auditory learners. What we've tried to do is create little short 2-minute or less videos on certain topics. And one of the ones we have on our legal blog is on purchasing computers and software, and kind of talking about those things we just talked about, that RFP process and the things you should consider. The link below is to our legal blog, and you'll find the video on purchasing computers and software there. So it's an additional resource that's out there if you have issues with that topic. Piggybacking is probably our biggest topic we get a lot, because a lot of times people want to get what they want to purchase, but don't necessarily want to have to go through the process of the public bid law. So in our scenario here, we have a political subdivision. It knows that a neighboring political subdivision recently bid out the purchase of some equipment, and they want to know, can they piggyback on that purchase without having to do the bid process themselves? The answer to that is there is 2 methods that are out there and available to piggyback on an already bid out contract. The AG in 21-0005 kind of lays out both of the processes and talks about them, so it's a good resource out there. But essentially what he lays out is there are 2 methods for piggybacking that are recognized. There's the statutory method in 38:321.1, and there's the local services law, which kind of already exists for when political subdivisions or other entities want to cooperate and do things, projects together. Under those 2 processes, they each have their own rules, and we'll go through them real quick. But essentially, one thing you want to note is if at the end of the day, you're going to be looking for federal reimbursement, say like after a disaster, the feds are likely not going to consider either of these methods as competitive under 2 CFR Part 200. What that means, and John will talk about that later, is that you're going to definitely have to do some kind of cost analysis, cost benefit analysis to show doing piggybacking and getting them at that price is basically reasonable in the circumstances, because you're not doing competitive procurement yourself. So looking at the statutory method, this is one the legislature put in, and one of the biggest things you need to note from this is that it has to occur within 1 year of the bid opening of the bid out contract. Once you get past that 1 year of bid opening, you can no longer use this method. With that said, you need to make sure that the original contract that was bid was in compliance with the public bid law. Essentially what the law says is you can get a certification, an email, something in writing from the entity who did the original public bid that says, we followed the public bid law for this process. And you can rely on that certification. They're essentially attesting that they did everything they were supposed to do. Another thing to understand is that total purchases under that piggybacked contract cannot exceed 2 times what was purchased under the original contract. If you stop for a second, it makes sense for why that restriction would be there. If that original contract, for instance, was bid out by a small village, let's say they were buying police cars for their village's police department, they're probably only buying a couple cars, 1 or 2 anyway. You now have a city who wants to piggyback on that contract, whose needs might be 5 or 10 times as 5 or 10 cars. It doesn't make sense to piggyback off the little small villages contract, because if you bid it out yourself, you're probably going to get a better price because of volume discount. So it doesn't make sense to take a contract where only a few things are bought and try to buy excessive amounts by piggybacking. The legislature basically said, no, we're going to limit you to up to 2 times as much. Beyond that, you can't use this method. You'll have to follow the normal process. Part of that process is going to be getting that written consent from the one the political subdivision who originally bid it out, getting that contract number from them and documenting any of your files. And if they had a resolution accepting that contract, you'd want that in your files as well. Anything you can do to support that original contract was done properly, and that you're using the same contract with that same vendor for the same materials and at the same contract price. So that's all things that are important, because the idea is it's as though you stepped into the shoes of the entity who originally bid it out. And so you want to make sure all those things are documented, that the vendor agrees to it, and that you can show what you bought without bidding it out is the same that was bought under that contract within a year of the closing, a bid opening, and that it was done through a contract that was originally done right. Now, the local services law, this is a little older, and this is where the AG has interpreted the local services law to allow piggybacking between two political subdivisions. According to the AG, that original contract had to have been bid in compliance with the public bid law. Where it differs from the statutory method is, whereas the statutory method said it had to be within a year of the bid opening, the AG has said to use the local services law, that original contract still has to be active, fresh, or viable. What that means, for instance, let's say you had an original contract to buy, say, a fire truck. Once that fire truck is paid for and delivered, that contract is no longer in effect. It's done. You've completed everything under the contract. So what that means is, if, let's say, another fire protection district comes along and wants to piggyback, once that initial contract has been completed, it can no longer be used under local services law to be piggybacked. That said, you may want to look at when was the bid opening. You might be able to still use the statutory method, but it's important to note, to use the local services law, that contract still has to be in effect. Again, you'll need to get that written consent and that information as to contract number, contract details, as well as if there was a resolution to adopt it. Again, the vendor, product, and materials and supplies or equipment should be have to be the same. One difference that is between the local services law and the statutory method, the statutory method says that price has to be the exact same as well. Whereas the AG has said under the local services law, that price has to be the same or lower. So you could potentially use the local services law to piggyback and get a better price, which is something you'd want to document if you, as part of your cost analysis for FEMA. Just as those others, we have some additional guidance specifically on piggybacking. We have a video specifically on it. So it's something that you can easily pull up at any time or show someone else by providing them the link. Now, recurring purchases. This is one that I think a lot of people don't think about when they're buying stuff, because we get this question a lot. In this scenario, you got a town, they purchase a lot of paper. The purchasing agent wanted to know, hey, do we need to bid out these purchases? We're having so many of these purchases throughout the year, but someone tells them, nah, because those individual purchases never are more than 5,000, public bid law doesn't apply. Well, in the words of Lee Corso, not so fast, my friend. Essentially, the Attorney General has said, when you look at things that you're buying on a recurring basis, in the original opinion, it was more with a sheriff buying pharmaceuticals for the inmates. But if anything, where it's paper, office supplies, specific things that you're buying the same thing over and over and over again throughout the fiscal year, what you have to do is look at what is the total amount you're spending over that entire fiscal year. And so we've had questions sometimes, well, how do we know this? One of the best ways to look at it is look at what your budget was for the previous year and the year before that. If you're seeing on a continuous basis, you're spending a certain amount, you probably have a safe basis to say, that's about how much we're going to expect to spend in the next year. Obviously, it's not always going to work out perfectly, but that's a good starting basis to determine what is exactly how much are you going to spend during the fiscal year. Again, remember with the public bid law, if those purchases for the fiscal year are going to total 10 to 30,000, the public bid law kicks in and says you have to get at least 3 or more quotes and in your files to support who you pick from those quotes to make those purchases. If it ends up being more than 30,000, you've got to bid out that purchase from the get-go, unless you have some other exception under the bid law that would apply, say buying under state contract. Requirement contracts are essentially the method where an entity who knows they're going to buy a lot of materials and supplies, but they don't know how much. They know it's likely to be maybe over 30,000, but it's never a consistent amount, and they don't necessarily know how much they're going to spend. What those contracts essentially provide for is that you contract and say, you vendor are going to agree to provide these material supplies and or equipment over a period, usually a fiscal year, could be anywhere from a fiscal year to maybe 3 fiscal years. If we say we need this, you're going to provide it at this bid out price. You're going to guarantee us that we'll get it for this price, so that you bid it out. You don't necessarily worry about how much you're buying of it, because you're getting it for that price, as little or as much as you need during the fiscal year. I would definitely direct you to this AG opinion 21-0059. He kind of walks through what exactly is a requirements contract and what it isn't. You should not be using something like that for, in that case, it was talking about for public works, because by their very nature, public works are very specific, and the law now requires you to get an estimate probable cost of that specific public works project. You really doesn't coordinate with a requirements contract, because in that case, you don't know how much you're going to use. One thing for fuel contracts, and this is one we get questions sometimes, do we need to bet fuel purchases subject to the public bid law? Yes, they are a material supply. What the AG has historically recommended is, because fuel costs are so volatile, and anybody who's gone to the pump in the last week and saw the 10% increase knows that it's volatile. You need to make sure that you have some kind of mechanism to address that volatile pricing. So what I would suggest is, and what the AG has suggested is, you may want to do those contracts subject to a price index, so that as the prices go up and down, you're essentially following whatever the market rates and things are for those. Again, for recurring purchases, we actually have a video on that as well. And one thing I would say, if there's ever questions you see and you don't see a video for this, we'd always welcome if someone says, hey, how about a video on this? Because we're always looking for what is the next topic that would be beneficial for these videos. So if you ever have some thoughts on those, please let us know, because we always welcome any kind of suggestions on that. Trade-ins. This is one we've actually got a lot of questions lately. In this question, you got a political subdivision, as many of them do. They're ready to replace those old vehicles, the ones that have fully depreciated out or aren't running as well, and they want to replace them with new vehicles. So you got an agency head who says, hey, is there any way we can trade in those old vehicles so we can reduce the cost of those new vehicles? And if you've ever you've been around a dealer in the last, say, 6 months, they're all asking to buy your used vehicles because they're worth a lot of money right now. However, the answer to that agency head would be, can we trade in our old vehicles as part of that purchase of the new one? No, trade-ins are not allowed currently. Why? The law, and as the AG has talked about in those transactions, you have to basically treat it as two separate transactions. One, your old vehicles, you need to dispose of those via surplus property laws. The surplus property laws are very specific about what you have to do to get rid of your old equipment and vehicles. And then for the new vehicles, you have to purchase them following the public bid law, and specifically under those procedures. The reason why you can't do a trade-in is because if you look at the statutory requirements that are required for each of those transactions, they aren't compatible. You can't follow what is required for surplus property law and follow what's required for public bid law under a single transaction with a trade-in. They just don't work. Part of that is because if you look at both of those processes, they are both set up to mandate that you get the best price. Because when you're selling off an old public vehicle, you want to make sure, because of Article 7, Section 14, that you're not donating that vehicle. You're getting fair market value of whatever that may be, whether it's for the vehicle or as scrap, that the public's money is being properly upheld when you're selling it. Anybody who's ever went in to sell a vehicle as part of a trade-in, you'll realize, or if you've ever looked in, like, say, Kelly Blue Book, trade-ins are always going to get a lower value than if you just did it at a sale, because part of what you're losing in value is convenience of that they'll take it from you while they're giving you the new vehicle. It's not so much about we're giving you a good price. And so the biggest thing to take away from this is there are two separate transactions required. The old vehicle, make sure you follow surplus property. And for those new vehicles, make sure you follow public bid law. We actually have a good vehicle on the surplus and purchasing, a video on the surplus and purchasing of vehicles, so that if someone ever questions you, let's say you're the purchasing person for your agency, someone says, well, is that really true? You can direct them to our video and let it explain to them how those two processes just don't work together, and you need to do it as two transactions. Contracts for goods and services. Another way to look at this is if you have a contract that's mixed. So in this scenario, a political subdivision is looking to enter into a contract that involves both the purchase of materials and supplies and professional services that are going to be rendered. So in this case, you want to know, is that contract subject to the public bid law? What the AG has said is it depends. You have to look, according to the AG, is what is the predominant portion of that contract? So if you have a contract that has materials and supplies and professional services, look at which part is the most, makes up most of the cost, most of what's actually going to be done. An example the AG has given is food service contracts that school cafeterias have, because even though the service of the food is part of that contract, he said, in reality, the purchasing of the food itself is clearly the biggest portion of that cost. And so because that's the predominant portion of that contract is going to be treated as a contract for materials and supplies, and you have to bid it out. Conversely, there's been opinions where the HE has said, where you're doing, say, repairs to equipment, if the parts that are needed are very small part of the price, but it's intensive labor and is the biggest part of that repair cost, he has said in those cases you treat it as a contract for professional services. The material and supplies are incidental to the real cost, which is that labor cost to repair the vehicle. And so in any case, when you're faced with a contract that's a mix of those, lay it out, look and see how much is the percentage of the cost for the service, how much of it is for the materials, and how much time is going to be spent potentially on the labor, things of that sort that are part of that professional service cost, and weigh it against the cost of the materials, and then document that so that when, if you're, let's say your CPA comes in and says, hey, why did you treat this as a professional service? You'll be able to say, we looked at both parts of this, we weighed those, and this is how we reached that conclusion. Probably not a bad idea to have whoever your legal counsel is make that in a memo to you, looking at it, looking at the AG opinions, and giving you that guidance to put in your file. So with contracts, goods, and services, you always want to make sure you kind of look at what is that predominant portion. Before we go to the last part of this, we'll take a second, stop and look and see what kind of questions we got so we can kind of go through that. So one of the questions would be, what would be a good reason to reject the lowest quote? One example that we've seen before, let's say it's below the threshold for bidding, back when vehicles could still be purchased for below the 30,000. And you have one quote that's say from Houston and another quote that's say from the neighboring big town here. One reason you might want to look at it is if we have issues with that vehicle and we have to go take it to the dealer to address any of those issues, it's going to cost a lot less to go to this one right here than it would be to drive or have it shipped to Houston to get it fixed. Things of that sort could be things. Ideally, you're going to look at what are those other costs involved that could be associated with it. And you want to document why it's in your best interest of your entity to choose that other quote rather than the lowest. And one of the questions was, what about changes in supply chain issues caused by COVID? Still, it's one of those things, if it's part of a bid and someone has said, here's what I'm going to charge you for this material and supply, that bid they're subject to. They're in default if they don't do it. Obviously, there could be a situation, let's say a hospital, where it needs supplies, and maybe that could be an emergency depending on with COVID. One thing they may want to look at before they run to the disaster, though, is there something they can piggyback on? Is there something under a state contract? Because any of those things that are alternatives would allow you to purchase it without going through the bid process. That may be still a scenario, and that could also be documentation if those aren't available, could be part of your explanation of here's why this is emergency. We've looked at these alternatives, they're not feasible, and we need it by this date. Those are things you would document as part of why you declared it an emergency. One of the questions was, is there any guidance and requirements for bid or RFP for software upgrades that are required for accounting systems? Software is going to be still a material and supply, but software is included in the things that can be done through the technology procurement. So you could follow that normal RFP process. As far as any specific things like someone who's done it, you may want to reach out to another entity that had similar purchases and ask, hey, can we look at your RFP? Just so you can see what they use, what worked for them, if whether things that came up in that process. It's always good to talk to someone else who's done that same type of RFP or bid, so that you can kind of see how did they word it, were there issues with how they worded it, to kind of learn from their mistakes or from their successes. If the question is, technology procurement for equipment has to be public bid law or RFP if the materials are over 30,000. No, if the equipment meets the definition of the data processing or technology equipment under that specific technology procurement law, it doesn't matter how much it is. It can be a mixture of services, it can be a mixture of software and materials. You follow the RFP process regardless of amount if you're under that law. If that law doesn't apply, then you have to look at the amounts under the public bid law. If it's at 10 to 30, then you need to be getting quotes. If it's over 30, it needs to be bid out unless you can find another exception that would apply. And can political subdivisions utilize the state procurement contract that are governed by 38? There are procedures for doing that where you can adopt a procurement code, or if it's a state contract, the public bid law allows you to use that state contract without doing any other things. What we generally recommend so that you have documentation in your file is that if you're going to use a state contract, have something either in your minutes, maybe adopt a resolution, or have something in your files that show we didn't bid this out because we bought this under this state contract. Here's the contract number. Here's the item under that state contract, so that if let's say you're getting audited, they come in and they see, hey, you didn't bid this out, but you have documentation that shows, well, there was this state contract for this item, and this is what we bought, so that that person knows, okay, they didn't need to bid it out, they bought it under state contract. If you have specific questions, though, about state procurement contracts, please reach out to us afterwards. On one of the last slides on here, we have our contact info. We'll be happy to walk through your individual questions for your individual situations. So for a school district, this is the next question. For a school district with many schools, is the total spent per year for the entire district or per school? If it's materials where the school board is buying it for the entire district, they should be looking at their total amount they're spending. And so it's going to depend on the entity that's actually buying it. But if it's at the school district level that they're spending the money for the entire district, they need to look at what the entire district is spending under their budget. Again, school districts may also want to look at if there's existing state contracts out there in some cases for some of those things they're buying. Those would not be subject to public bid law if they're done in that way, or if they're buying it from a qualified group purchasing organization, which we'll talk about in a minute. Well, the question is it the same item or just office supplies in general? It depends. In most cases, though, let's say paper, you're looking at how much paper you're buying, because you may not buy pens or something near at the same level. But if you're buying as a category of just office supplies, where you just in general buying from a place, you'll want to make sure that you're looking at it from how you're doing it. One of the things we had question was with price changing so frequently, vendors are hesitant to bid out annual contracts within a fiscal year. One thing you can do, if it's say it's more than within a fiscal year, they should be committing to a price. But in cases, let's say you're doing a multi-year contract, one of the things you can incorporate into a contract is an escalation clause. So like for inflation and things of that sort, you may allow like say a 1 or 2 or 3% escalation clause, depending on what the item is, to allow it to kind of, if it's a price that always goes up for that material, to allow it to grow over multiple years. If it's something that's a volatile pricing, like say we talked about earlier for fuel, you may want to use some kind of established price index that's out there that says, hey, look, you're going to do it within so much percent or so much cents of the price index price, and that's going to be the fair value that you're going to give us for this, so that it's not like a markup price, but it's actually what the market rate should be. On trade-ins, if it's a law enforcement vehicle and they have a surplus gun, can it be traded into a vendor for the purchase of another equipment? Guns, I would say there are specific laws and rules for firearms. If you have that question, please reach out to us individually and we can look at your specific circumstances. But firearms are have different specific laws for those than say for a vehicle. And so I would say on that question, reach out to us and we'll try to help you. There is some guidance that's out there. We had another medical equipment. It would still be equipment. However, if you're a hospital service district or a hospital, there are specific provisions, which we'll talk about in a second, for you to purchase off of qualified group purchasing organizations. And looking to see if we got any new different ones real quick. One of the questions we got was, who declares the disaster? Depending on what type of entity you are, let's say you're a municipality, the mayor is going to be the one who generally declares that disaster. If you're a parish, it's going to be the parish president or their equivalent, maybe the president of the police jury, depending on how you're established. But that executive person is generally the person who's going to declare the disaster. And then the legislative side is the part who kind of confirms it or has the ability at some point to say, we think it's over. But those two should always be working together, because even though the executive may declare the disaster, the legislative side is going to have to at some point address the budget issues for any monies that come in for the disaster or changes in operation that may result from the disaster, so that the budget continues to match what you're actually doing for spending. One of the questions was on foods. They're claiming since their costs have increased so much, they will charge us more. The AG has said they can't do that. Generally speaking, if it's bid out, by providing a bid, they are basically legally saying, we're going to give it to you at this price. And one of the things the law says for public works, those have to be reduced to a written contract. The law doesn't specifically mandate that purchases of material and supplies have to be a written contract, but it provides you can, as the public entity, mandate that as part of the process. Given some of the issues with cost increase and where they're trying to get out of what they bid for, you may want to look at doing written contracts so that once they submit a bid for that material supply, have your legal counsel draft up a contract that makes it clear they're going to give it to you for that price for the term, that whatever it's a one-time or over a fiscal year or multiple fiscal years, so that you have recourse later that you've documented that they are clearly committed to that price. So as far as things, in the words of Steve Jobs, one more thing. One question we've had recently is with national co-ops. We've seen a litany of questions coming from all kinds of political subdivisions on, we're assuming these national co-ops are trying to advertise to these in local political subdivisions to buy from them. So in our last scenario, we get the political subdivision is contacted by a national co-op. This is the same question we get all from them, and this is what they're being told, that we have all these contracts, materials, supplies, and equipment. We've competitively bid them out under whatever their state law is where they're organized, and that their rules or their state law says, hey, we can provide these contracts at these great prices to political subdivisions wherever they are in the country. So the question becomes, can we as a political subdivision of Louisiana buy off that national co-op's price list? Well, the public bid law only authorizes currently hospitals, hospital service districts, school boards, school districts, and schools to make purchases off of co-ops and group purchasing organizations. Everyone else, the AG has said, they cannot piggyback or otherwise purchase off these contracts that were not originally bid under Louisiana public bid law. What this means is you have this national co-op. There's one I know it's out of Texas. They follow the Texas laws, which may be similar, but the AG has said if it wasn't done under the Louisiana public bid law by a Louisiana public entity, you cannot piggyback off that contract. It has to be between two Louisiana political subdivisions. That said, what the AG has said, and we've actually seen some scenarios where it's occurred, the Office of State Procurement, under its rules, has the ability to adopt existing contracts that were not necessarily done under Louisiana law, but that through their procedures to identify it as a good contract for state agencies and others, they can adopt that contract as a state contract. If they do that, what the AG has said is, then that contract is like any other state contract, and you can actually use you can use that state contract then. We've actually seen in some of the questions we got recently on some of these co-ops where the state procurement has specifically done that. We've seen no evidence where they've wholesale adopted all of their contracts, but there are specific contracts that on the price list of co-ops where they have gone in and adopted those as state contracts for that specific vendor and supply. So what I would suggest is if you see a contract that you just don't see it available anywhere else at a good price, and it seems like a too good to be true contract, reach out to the Office of State Procurement. Let them know about it. If they choose to adopt it, then congratulations, you can now use it as a state contract. But until then, you just can't piggyback or use those out-of-state co-ops. Real quick to kind of summarize for the hospital service districts and the schools, I would direct you to our FAQ on public bid where we have sections specifically for those, because there are specific rules to determine if they're a qualified group purchasing organization. And specifically for schools, because we've gotten this question recently, you need to be in contact with the state Office of State Procurement, because one of the restrictions is you can't buy something from a co-op as a school if that same item or a similar item is available cheaper under existing state contract. So you'll want to definitely check with state procurement, document that as part of your files before you go purchase from that co-op. So now I've built in a little time for questions, and I see we have a few that are still out there. So let's go through a couple of those, and so we can make sure to see if there's questions that maybe we haven't addressed yet. What about software upgrades? Well, if that software upgrade is actually buying new software, which is what you really need to look at what you're purchasing, that would be still a material supply. But it could fall under the RFP stuff because it still fits within that technology procurement. If what you're buying, when we get this question sometimes, a subscription, you don't actually own any of the software, it is just a subscription. When that subscription runs out, you don't have access anymore. That we and the AG have historically looked at it as more as a service, because you don't actually buy anything in that case. You're just paying for access to stuff. So you're paying it more like a service. So you always want to kind of look at what are you really buying? What are the natures of it? And talk with your legal counsel so they can look at what is the legal consequence of what you're trying to do, because software is always a big deal. The other issue the AG has dealt with software, if you're buying software and then someone like the off the shelf, that's purchase. If you're buying software and someone's going to update it or make it specific to you, that's going to be those mixed contract circumstances. You need to evaluate the cost of the software and the services that they're going to provide and customizing it. If they're just creating something from scratch, that's going to be more a service, because the predominant portion is they're creating it. It doesn't something you're buying off the shelf. Technology procurement services is a threshold. No, as we talked about, under technology procurement, there is no thresholds, just a requirement that you follow the process for the RFP and that what you're buying actually fits within that law. Does a school district have to advertise for banking services? That one I would say, because it's not really part of the public bid law, reach out to us and we'll look at your specific things, because it may depend on the populations, what procedures you have to follow for that under local depositories. And we have an FAQ on local depositories for selecting banks. Let's see. Legal services. No, that's going to be a contract for services. Contract for services for local government, political subdivisions is not subject to the public bid law. Obviously, Article 7, Section 14 is still going to apply to any procurement you do, even if it's for services. So you want to make sure you're getting a fair value. You're not just paying an exorbitant amount for something. If you have specific questions about purchasing legal services, reach out to us, because there's some other things that the AG has over time said you need to be wary of when procuring legal services to make sure you're not just paying money to someone and not getting services in return. Subscription softwares for hardware, software, and professional services. I would say on that one, call us, because we need to know specifics on what we were talking about for a subscription contract. one thing to remember for public bid as a general, if it's a true lease where you're leasing something and there's no option to buy either, or that you get the equipment at the end, the AG has said a true lease, like in that circumstances, is not going to be subject to the public bid law because you don't actually buy and own something. What price percent off list would be acceptable for an index escalation? It's going to be very fact specific. What are you buying? What is the like an industry standard for that? The key thing again under Article 7, Section 14 is you want to make sure it's a fair value. So that's really going to be very fact dependent on what you're buying. Any special provision of the bid law for parishes purchasing used road equipment? Road equipment, there isn't, but there is for used emergency equipment for like the actual fire truck, ambulance. We have some questions out there posted on that, but if you had some specific questions that, please reach out to us and we'll try to help you on it. Can a mandatory pre-bid conference be conducted virtually? Depends. That's when I'd say reach out to us so we can see your specifics to see what exactly you mean by conducting it virtually and what that conference would be. There may be ways that would be acceptable. Where can you find existing state contracts? That's a great question. If you go to the Office of State Procurement, they have a couple of different lists that are out there. One is the ECAT, where you can do a search by vendor or by specific product. But if all else fails, what I always recommend to someone is call the Office of State Procurement. They have specific individuals who are tasked with governing certain types of contracts. They can easily help you identify if there's a state contract out there for what you're looking for. And so they're always a good resource to reach out to. Let's see. Sole source. This is one we didn't put in here, but the general answer is if you're subject to the public bid law, there is no such thing as sole source. The only thing that provides for sole source is the procurement code. So unless you've adopted the procurement code, including that parts, and followed the procedures that are required for sole source is not a thing. What I can count on one hand the times the AG has said something was so unique that they didn't require it to be bid out. But generally speaking, the public bid law says you put something out for bid, you advertise it, and seek responses. So there should be no such thing as sole source, because the other aspect is you can't have closed specs. Under public bid law, you're required to accept things that are similar, that are functional equivalents. So like if you want a Jeep tractor, or let's say a Caterpillar, you have to accept some other brand that does the exact same thing if it's a lower price. And so you can't go closed spec. So sole source really isn't a thing. And in today's age, sole source doesn't mean only one person makes it. The example I usually use is Apple computers. Apple is the only one who makes Apple computers, but you can buy an Apple computer from a lot of places, whether it's Amazon, Best Buy, even Walmart in some places. Because when you look at who is selling it, if there are multiple vendors, even under the procurement code, that would not qualify as a sole source. So you always want to be leery when somebody says they're a sole source. Put out your bid. If they're the only one who responds, congratulations, you can give it to them. Let's see. Oh, someone wants to know, what is there a difference between RFP and RFQ? Simplest thing is an RFP, it's proposals usually for them to come in and do both buying and providing equipment and usually services. Whereas an RFQ is the process. Usually you're using it for like your architect, engineer, and landscape architects. It's a request for qualifications where your criteria aren't based on price or specifics. It's based on, do you have the experience and qualifications to do what we're asking you to do? Usually some type of design services. And so that's really what the difference is between those. So with that, what we'll leave it at this is that if we didn't get to your specific question or you have specific questions that come up, please reach out to us. We're always happy to sit and talk with you on the phone. We always say we're not the AG, but we're always happy to talk with you. As our general counsel, Jennifer Shea, usually says, if you call us and we don't get back to you within 48 hours, you probably need to send the cops because something's wrong. And so we pride ourselves on trying to get back to you as quick as possible. And if we don't have the answers, we like to at least try to leave you with someone who can potentially help you with your questions. So it's been a pleasure today. Again, if you have any other questions, please reach out to us and we'll try to help you with your questions.
Thanks so much, Patrick. Okay, guys, we have about 5 minutes until our next session starts. So bear with us. We're going to transition from our next instructor. So take the next 5 minutes to stretch your legs and get a bathroom break.